Good afternoon and welcome, everyone. Looks like it's noon, so we will get underway. My name is Charles Cobbins. I'm the Client Services Manager for Holland & Hart's healthcare practice, and I'd like to thank you all for joining today's webinar on reproductive rights, the status of federal and intermountain state laws. Today's webinar is intended to help you understand the relevant abortion laws now in effect or pending throughout the intermountain states and the implications for healthcare providers. We'll post a recording of today's session along with the presentation on Holland & Hart's Health Law blog within the next day. Once the recording has been posted, we'll send to all registered attendees a link to the recording and to the presentation. Should you have questions during today's webinar, please enter those into either the chat section or the Q&A section on the right side of the screen. Time permitting, the panelists will address your questions at the end of the presentation. Otherwise, they'll respond to your questions via email as the questions will be captured via WebEx. One quick note, today's presentation is designed to provide general information on pertinent legal topics and is provided for educational purposes only. The information conveyed does not constitute legal or financial advice, nor is it intended to create an attorney-client relationship between you and Holland & Hart. So without further ado, I'd like to introduce you to today's panelists. First, we have Ashley Kennedy, an associate in our Salt Lake City office. Ashley's practice focuses on intellectual property and technology transactions. She counsels clients on structuring and addressing the intellectual property components of mergers and acquisitions and other corporate transactions, including clients in the healthcare industry. Next, we have Christy Kimball. Christy's a partner in Holland & Hart's Salt Lake City office. She advises health and life sciences companies on a spectrum of operational and regulatory issues, including fraud and abuse, HIPAA, state licensure and credentialing, and FDA regulations. Christy serves as outside counsel to several major hospitals, healthcare businesses, medical device companies, and tech companies operating in the healthcare space. I'll now hand it over to Ashley to begin. Thank you.
Hi, everyone. Thank you so much for joining us today to talk about the legal developments in reproductive health care. I'm just going to give you a quick overview of what we'll be talking about. I'm going to start off by discussing a burning topic in this field at the moment. It's at the federal level, and it's recently been the subject of considerable litigation, and that is the availability and legality of prescription drugs that are capable of inducing abortions. So mifepristone is a drug that blocks a hormone called progesterone, and that's needed for a pregnancy to continue. And when it's used in combination with an additional drug called misoprostol, it can end a pregnancy within the first 10 weeks of gestation. So some anti-abortion doctors brought this case in a forum with a well-known anti-abortion judge. His name is Judge Matthew Kaczmarek, and he presides over a federal district court in Texas. In a preliminary ruling, the Fifth Circuit Court of Appeals said that mifepristone could be used for up to 7 weeks, but the FDA responded that the Fifth Circuit's ruling would cause chaos throughout the country. So in April, the Fifth Circuit Appeals Court panel said that the drug could remain on the market while the case was being litigated, but it did order a reversal of all regulatory actions that the FDA has taken on mifepristone since 2016. And this included the approval of a generic version of the exact same drug that's manufactured by a company called GenBioPro. And this caused GenBioPro to file a dueling lawsuit that we will discuss in just a minute. So the Fifth Circuit's interim ruling was appealed to the Supreme Court, and there has been a lot of discussion about this recently. So it was appealed by the Justice Department, and they requested an emergency appeal. And the Justice Department's administrative brief used pretty strong language in urging the Supreme Court to block the lower court order. So I'm going to quote what the Justice Department said. They stated that the district court countermanded the scientific judgment that the FDA has maintained across 5 administrations, nullified the approval of a drug that has been safely used by millions of Americans over more than 2 decades, and upset reliance interests in the healthcare system that depends on the availability of mifepristone as an alternative to surgical abortion for women who choose to lawfully terminate early pregnancies. Their brief also said that harms would be felt throughout the entire country because in every state, including the states that ban abortion, mifepristone has lawful uses, and those uses include treatment of women who are miscarrying. So Biden's administration also took the position that the anti-abortion doctors challenging the FDA regulations in the Texas case had absolutely no right to be in court at all because they had no concrete stake in the drug. So they neither take it nor do they prescribe it. And those doctors also haven't found a woman who claims to have been injured by the drug. And the broader community, especially the business community, has lined up with the Biden administration. Most businesses are fairly concerned that the entire regulatory structure of the FDA and its job to ensure safe medications is currently at stake. So this kind of came to a head last Friday when the Supreme Court justices granted what's called an administrative stay, and this blocked the lower court orders until April 19th. Sorry, this wasn't last Friday, but the permanent stay was granted, and that's not very long. So they granted this permanent stay later on. And what this administrative stay did was freeze the status quo. And that allowed the current drug regimen for mifepristone to remain in place while the other side had time to file a reply to the government's appeal. So at the moment, we are in the kind of in limbo. We're waiting for this administrative stay to expire, and it looks like next week a Fifth Circuit panel of 3 very conservative judges that are hostile to abortion rights will hear the case. So if the Supreme Court had not issued that stay, the lower court's orders limiting access to mifepristone would have immediately gone into effect. So if Kaczmarek's order is ultimately upheld by the Fifth Circuit, it won't take effect until after the FDA has a chance to appeal it to the Supreme Court. So now we'll discuss a little bit about the second mifepristone case that GenBio Pro filed. So GenBio Pro makes the generic version of mifepristone. And they are concerned that if the FDA complies with the Texas court order, ultimately ordering mifepristone off the market, that they will essentially be put out of business. And so GenBio Pro filed this case in the U.S. District Court of Maryland. And this lawsuit basically claims that the FDA has repeatedly failed to stipulate that it would follow the regulatory process that Congress has already established and afford GenBio Pro due process rights that are guaranteed by the Constitution if the FDA is ordered to suspend or revoke its approval of GenBio Pro's product. So GenBio Pro's chief executive is very concerned about this, and he said that the outcome of the Texas case has already led to fewer orders of mifepristone. He said that it's already impacted orders that include tens of thousands of units, and it's causing considerable market disruption in his field. So let's talk about what happens if the Texas order is ultimately granted and the Maryland case issues a conflicting ruling. So the US is currently set up for a very real possibility that 2 federal district courts could issue rulings on the abortion pill that conflict with one another. And this potentially could add further confusion to a very complex web of different state regulations on mifepristone. Further complicating this issue are 2 additional lawsuits that have been filed by Democratic attorneys general. So there's been one filed in Washington and another filed in Virginia. And both of these lawsuits name the FDA as a defendant, and they request court orders lifting current federal restrictions on mifepristone, so going the exact opposite way of the case in Texas. And those current federal restrictions on mifepristone include a requirement that pharmacies be specially licensed to dispense it. So ultimately, we could have a situation where in some states it's not available, and in some states it is available. All of these things are possible, but a lot depends on how these judges ultimately write these rulings. And when we have conflicting cases at the lower federal level, it's pretty likely that they'll ultimately end up back at the Supreme Court. So I'll now turn the time over to Christy to discuss Title X clinics and family planning.
Thanks so much, Ashley. Next, many of you have probably heard about another case out of Texas with this same judge on the first mifepristone case, Judge Matthew Kaczmarek in Amarillo, Texas. a case was filed last year by a father of a minor who objected to the fact that his daughter could get birth control at their local Title X clinic, which are normally Planned Parenthood clinics. So, as many of you know, Title X is under federal law. There are funds for family planning, and those funds are given to various clinics under Title X, and all Planned Parenthood clinics are receiving Title X funds. In long set precedents for decades, precedent has held that those clinics that are funded by Title X can provide basic health care, including birth control, family planning, to minors without parental consent. So that's been the one consistent across the states through these years, because in some states you have laws that allow minors at a certain age to access family planning, birth control without parental consent. In other states, for example, like Utah, that are more conservative, there are no, carve-outs allowing minors to consent to their own to getting birth control, reproductive health. So it just really depends. And the one, again, consistent thing that we've had is that regardless of those state laws, federal law trumped in this area, so that minors, if they would go to a Title X clinic, i.e. Truly a Planned Parenthood clinic, they could access birth control and family planning resources without parental consent. However, in this case, and clearly you can see, right, that there's forum shopping going on by the plaintiffs in these various cases that are being brought, because this case was brought very specifically in Amarillo, Texas, with this same judge that is known to be very conservative. In December, this judge did rule that it violates Texas state law and the U.S. Constitution for minors to get their birth control through the Title X program without parental consent. However, in February, the U.S. Department of Justice appealed the ruling. So at present, we're waiting to find out the implications of this ruling, which will really be determined on appeal. So that obviously has been something that's been concerning to a lot of providers, trying to determine how to navigate this, and also trying to decide what guidance to give. For myself, being a healthcare attorney, there are a lot of times where I do get the question from clinics that are in private practice about these issues of, can a minor consent to family planning, to birth control, to the provision of birth control. And in Utah, there's only one little exception, and it doesn't really cover this birth control. It's really only if somebody professes or is concerned about having an STD, then they can consent to their own care. But for just being concerned about contraception and birth control, Utah law doesn't have a carve-out that allows minors to consent to that. So when physicians call me and are asking about that, I inform them of that fact, but tell them that one workaround is that they can always tell these minors that if they can get access to a Planned Parenthood clinic, that they could go there and get those resources without parental consent. But of course, now with this ruling that's now on appeal, that is now up in the air, and we'll have to wait and see as this case moves through the courts to find out, the impact of this ruling. Right now, it's in Texas only that they are following this precedent. Outside of Texas, people have not been following this precedent while it's on appeal. But again, if on appeal it gets upheld, and if the ruling says that it does apply, of course, across the nation, because this is dealing with federal law, then that would be something that would really change the landscape for all providers. So now we are going to turn to state law issues. And several months ago, after the overturning of Roe v. Wade, we did a webinar where we talked about the laws in the states that Holland & Hart has offices in. And of course, a lot has changed since just those few months, and a lot will continue to change in this landscape because there will be litigation for years to come dealing with so many of these laws. So the landscape will be changing, but we wanted to give an update to you as far as the areas, the Intermountain footprint where Holland & Hart operates, and talk about the various state laws here. So with that, we are going to start and talk about Utah. So right now, many people know that our trigger law, which was passed in 2020, and we've outlined what that trigger law is in the table on this slide. However, it was enjoined very quickly, and it's still enjoined. So at present, currently, abortions are legal in Utah up until 18 weeks. But again, if the lawsuit, as it moves through the courts, to the extent that at some point in time, this ruling is no longer enjoined, then the following trigger law would be put into effect. There are carve-outs in Utah law to avert the death or serious physical risk of substantial impairment of a major bodily function of the woman. There is a carve-out for if there are two physicians who practice in maternal fetal medicine, if they concur in writing in the chart that the fetus has a fetal abnormality that in the physician's reasonable medical judgment is incompatible with life, then that is another carve-out. And then there is a carve-out for rape or incest. I wanted to mention that these carve-outs, these laws are changing. So while the trigger law in 2020 had certain language, in this last legislative session, they did make changes to some of these definitions. And one of those changes has been that prior, the trigger law in Utah said that there was a carve-out for rape or incest, but only if the physician verified that a report had been made to law enforcement. In the last legislative session, due to concerns regarding that, most of that requirement was stripped out. However, there still is a requirement if there's a pregnant female that is under the age of 14. So, very, very young. But if she's, 13 and younger and pregnant and claims that, the pregnancy is due to rape or incest, then in that case, the physician must verify that the rape or incest has been reported to law enforcement, and that any child abuse mandatory reporting has occurred where that's applicable. So that's where we stand on Utah law. We'll go to the next slide. We're going to just keep providing you some of these updates because, again, every legislative season, we're going to be seeing changes to these laws, and we're going to be seeing new laws. A lot of the laws that we're seeing being enacted and proposed at the state level in many of the conservative states like Utah are coming at the federal level from federal pro-life groups and associations that are drafting model legislation and then pushing that down to the states and getting various state legislators to bring that legislation forward in these states. But just by way of making sure that everyone understands that there are certain things happening at a national level that you're seeing then proposed legislation that's coming down in some of these conservative states. But on March 15th, 2023, our governor here in Utah signed legislation enacting a new law that generally requires abortions be performed in hospitals and prohibits future licensing of abortion clinics and increases restrictions on abortion availability. However, Planned Parenthood has sued over that law, and the law is currently enjoined. So again, we have to keep following these cases pretty carefully to find out what the status of the law is really at any point in time. I wanted to mention also that as attorneys at law firms that have access to these major, legal databases like LexisNexis. We have access to these databases where they are tracking at a state level every single change that's happening, the status of cases that are moving through the court systems. And it can be really hard as a layperson to keep track of exactly what's happening. But for any of you listening, if you have questions, please make sure to contact us, because we can easily log into these databases that have the trackers that are being updated, and we can very easily find and see exactly what's happening at the state level with these various pieces of legislation and any litigation that's happening relative to those pieces of legislation. So hopefully that'll be helpful to you, but wanted to make sure that you're aware of that. Moving on to our next law, next state. Idaho, of course, is another conservative state. Idaho, I would say, has been particularly challenging and particularly confusing due to several different laws related to abortion, and then a lot of different lawsuits that have been happening in regard to those laws. But basically, abortion is prohibited from now, as it stands now, abortion in Idaho is prohibited from the time of conception due to Idaho's trigger ban, and that went into effect in August. Now, it was enjoined to the extent that it conflicted with EMTALA obligations, and is still enjoined to the extent that it conflicts with EMTALA, but otherwise it is now in effect. However, in July of this year, July 1st, 2023, the total abortion ban does not apply to ectopic or molar pregnancies. And that's because, of course, as these bans went into effect and concerns are raised, the legislatures in each state are considering changes that need to be made. And so there was a legislative change, an amendment, and again, that goes into effect July 1st. Also, instead of characterizing them as affirmative defenses, the total abortion ban now excludes abortions that are necessary to save the life of the mother or that follow reported rape or incest. But again, it's got to be reported. This will shift the burden of proof relating to the exceptions from the defendant to the prosecutors. Last, the rape and incest exception only applies if the abortion is performed during the first trimester of pregnancy. So that exception is not going to allow an abortion to happen after that first trimester. Additionally, if we'll move to the next slide, many of you have probably read about this, it's been in the news, but Idaho has now enacted a civil liability law that allows certain individuals, including any female upon whom an abortion has been attempted or performed, the father of the preborn child, a grandparent of the preborn child, a sibling of the child, or an aunt or uncle of the preborn child, can maintain a civil action against the medical professionals who knowingly or recklessly attempt, perform, or induce the abortion in violation of Idaho law. So again, this allows individuals that have some skin in the game, so to speak, who are related to this unborn child. They can bring a civil action against medical professionals if they perform an abortion that violates Idaho law. Another law, if we'll move to the next slide, that has just very recently been in the news as being, I think, one of the most restrictive pieces of abortion legislation in the nation. In this past legislative session, the Idaho legislature passed a new abortion trafficking law. And that went into effect on May 5th, 2023. So just a matter of a few days ago. And it makes it a crime for an adult to recruit, harbor, or transport a pregnant minor within Idaho to obtain an abortion, including an abortion that's done out of state, without the consent of the parent or guardian. The parental or guardian consent is affirmative defense, but the fact that the abortion provider is in another state is not a defense. And violations will result in prison of 2 to 5 years. Now, Planned Parenthood has vowed to challenge the abortion trafficking statute And so we are expecting, litigation relative to this law. So you should, really keep an eye on this. The one thing I wanted to point out too, in regard to Idaho's laws, that again, there are several different laws in Idaho that make it difficult to kind of track sometimes what's going on and make it tough to decipher. Kim Stanger in our Boise office has done a really wonderful job of continuing to track and put out client alerts related to the Idaho laws as they have been changing and as the status of their legality has been changing. And at the bottom of the slide, we have included a link. So when you get the slide deck, this is linked directly to a Holland & Hart client alert related to Idaho abortion law update that Kim recently did that goes very in-depth into Idaho law, explaining the various facets of these various laws and the nuances. So I would really encourage anybody that's dealing with Idaho law to access that resource and get the additional detail that you need from that resource. Now we're going to be moving on to Wyoming, and I'm going to turn the time over to Ashley.
Yes, so I will discuss Wyoming, and it currently permits abortions until viability. However, there was a trigger law that was enacted. However, that is currently enjoined. So I'll just give you a brief overview of this law. If somebody performs an abortion, they could be liable for a felony, and they could be punished with 2 to 5 years in prison. So Wyoming defines abortion as the act of using or prescribing any instrument, medicine, drug, or other substance with the intent to terminate the clinically diagnosable pregnancy of a woman. And they define pregnancy as fertilization. So this is different from some other states that define pregnancy as implantation. Some states, as we'll discuss later on, have a more in-depth definition of fertilization, but you can infer that it means upon conception here. So it does include some exceptions to this trigger law that has been enjoined again. It is to avoid death or substantial and irreversible impairment to the mother. I wanted to note, though, that this does not include any sort of psychological or emotional conditions. And there's also an exception to the trigger law for incest and sexual assault, but these acts must have been reported to law enforcement in advance of the abortion, and the patient also has to provide a copy of the report to the physician. There's also an exception for a lethal fetal anomaly as diagnosed by the physician. So some updates that have occurred recently in Wyoming law. So in March, Wyoming enacted a new law called Life is a Human Right. And this removed abortion from the definition of healthcare and prohibited abortions except in those cases that we just discussed. It also criminalizes the providers who perform abortions. Kind of in the theme of MIFEPRISTONE being litigated at the moment, the Life is a Human Right Act also made it unlawful to prescribe, dispense, distribute, sell, or use any sort of drug that could induce an abortion. And this becomes effective on July 1st, 2023. So we can't know yet if it will be enjoined. It may be, we'll just have to keep following it. Also in March, Wyoming District Court granted a temporary restraining order that prevented the Life is a Human Right Act from taking effect. So the difference between a TRO and an injunction is that a TRO is temporary and can prevent a law from becoming effective, but an injunction is more permanent, so it lasts for a longer period of time. So we'll see if a permanent injunction is litigated once this law becomes effective in July. So moving on to Montana. Montana is not as restrictive as the other states that we have discussed, and it currently permits abortions until viability. And a law that is not as restrictive, but is still attempting to change that, has also been enjoined. And this law is called the Montana Abortion Control Act. And this would permit abortions only until 22 weeks after the woman's last menstrual period. So if a person knowingly performs or attempts to perform an abortion, they could be liable for a felony. And this abortion definition is consistent with The other definitions that we have discussed, essentially to use an instrument, medicine, drug, or other substance to terminate a pregnancy, but the physician must know that the woman is pregnant. So there's a knowledge qualifier here. Pregnancy here is defined as fertilization, and Montana law has a more specific definition here, and it is the fusion of a human spermatozoon with a human ovum. So this also includes some exceptions to this abortion law, and it's to avert death or serious physical risk of substantial impairment of a major bodily function of the woman. Again, this does not include psychological or emotional conditions of that woman. There are also exceptions to this law to permit a physician to remove an ectopic pregnancy, and also to permit abortion in the case of rape or incest. So as you can tell, this law is slightly more permissive than the other more restrictive laws that we have discussed. So this abortion law in Montana has taken several updates throughout the last 2 years. So just wanted to kind of run you through that so you can understand how Montana has gotten to the place where the laws currently stand. So back in April of 2021, Montana initially enacted legislation that permitted abortion only until 22 weeks after a woman's last menstrual period. As we discussed, this law has been enjoined, and it was enjoined in August of 2022. And the Montana Supreme Court affirmed a lower court in Montana's order granting that preliminary injunction. So much more recently, back in April, the Montana legislature passed a bill that prohibits a physician from performing an abortion using a dilation and evacuation procedure. And that is a very common procedure used 15 weeks after a woman's last menstrual period. Later on in April, Planned Parenthood filed for a temporary restraining order to block enforcement of that bill. However, this TRO was not granted because the judge in that case found that Planned Parenthood's request for relief was premature since the bill had not yet been enacted. And as we've been discussing some more restrictive laws on abortion, we also wanted to emphasize some states that have taken steps to protect abortion. And these states are also in our footprint. So some of these are in Nevada, Colorado, and New Mexico. So Nevada, fairly recently, the Senate in Nevada approved a bill that would strengthen protections for abortion patients that are traveling into Nevada from out of state. And it would also protect those in-state abortion providers from outside prosecution and penalties. But note that this has not yet been enacted into law. It's currently sitting with the state assembly. Colorado enacted a law also in April protecting out-of-state patients that are seeking an abortion. And Colorado, this law actually ensures that those patients have safe and legal access to an abortion without any fear of prosecution, meaning that they can't be extradited to external states, perhaps those states where those patients came from. For example, if they came from Utah and are seeking an abortion and Utah wants to extradite that patient from Colorado for obtaining an abortion, Colorado will protect that patient and will not permit them to be extradited. So this law also bars state agencies in Colorado from cooperating with any out-of-state investigations into any patient's reproductive health care. So in New Mexico, they enacted a law back in March that also protects out-of-state patients that are seeking an abortion. And this law permits those patients to receive an abortion and, similarly to Colorado, prevents extradition of those patients and the in-state abortion providers. So I am now going to turn it back over to Christy to discuss some more developments in this space with respect to the FDA and their action on birth control pills.
Thanks, Ashley. I think one thing that probably is on everybody's mind, right? You're seeing these laws in these more progressive states that are trying to protect their citizens and protect access to abortion. And then in these conservative states, right, we're starting to see these laws where we're going to criminalize people who assist with individuals even crossing state borders to get an abortion. And so it's like, well, you know, whose laws are going to prevail? What will they be able to do in these situations? And we don't have great answers for that because these are matters of first impression and each state's laws are different. So we will see a lot of litigation in the next several years with these different state laws. Again, the ones that are protecting, the ones that are criminalizing, trying to see the extent that states' laws can have upon the citizens of other states. So that'll be incredibly interesting as things move forward over the next few years, but we just don't have a lot of good answers yet, which I know can be incredibly frustrating. But I do want to talk about, some other developments that I think are interesting. The FDA advisors just yesterday, advisors to the FDA unanimously endorsed making birth control pills available without a prescription, overriding concerns raised by the agency about whether the medication could be used in a safe and effective manner without physician oversight. If the FDA follows this non-binding recommendation, the medication called Opill would become the first contraceptive pill to be provided without a prescription on store shelves. So as we see the various states, right, and these various pieces of litigation trying to constrict access to abortion and access to, let's say, medication that induces abortion or even birth control, you've got the federal government and the Biden administration trying to protect to the extent that it can access. And this is certainly something that's happening at the federal level with the FDA. Perhaps if they do take this recommendation, we may see a birth control option become available, on the shelves of pharmacies versus being behind the shelf of the pharmacy. Next, also in relationship to EMTALA, I think what's really important is that, as most of you know, with EMTALA, hospitals with emergency departments, they have a legal duty to assess patients with emergent conditions and stabilize them. And there is a lot of juxtaposition right now, of course, between some of these state laws that are restricting abortion and hospitals' obligations under EMTALA. And this is really hard for providers in those states that have restrictive abortion laws, because physicians are put in a really tough position where they're not sure in certain situations, like how emergent of a medical condition does the woman need to be in before they can go ahead and perform an abortion that's necessary for medical reasons to really save the life or health of the mother. How emergent does that situation need to be before they can perform it, so that a physician is not at risk for being prosecuted under these state laws? And it's a really difficult situation. And you've probably seen across the country, we're now seeing lawsuits that are being brought by individual plaintiff females, where for various reasons they needed to have a medically induced abortion to save their life, and care was delayed, causing either a medical issue or a potential medical issue, and you're seeing this litigation start to take place. But in addition to this, just earlier this month on May 1st, CMS announced 2 investigations of hospitals that were alleged to have not offered the necessary stabilizing care to an individual experiencing an emergency medical condition and requiring abortion services in violation of EMTALA. In response, Health and Human Services Secretary released a statement reminding hospitals and providers of their professional and legal requirements to provide care for patients who need emergent care, including abortion care. And we've included a link to that statement in this slide deck that you can access when you have that. And then also the overall guidance that was issued previously. We've also included some guidance under MTAL that Health and Human Services has given. So, everybody, if you're obviously, most of the people are on the phone, you're in healthcare, but if you're associated with a hospital, you've really got to balance. You've got to balance those risks between these state laws that could be detrimental and where people could be perhaps prosecuted criminally, to liabilities under federal law, with CMS saying that you violated EMTALA by not providing, these services for patients that have emergent conditions. So it's quite the balancing act, and it's really tough when it's in real time, of course. Next, we've also included just other, additional links to other guidance that may be helpful. A link to Health and Human Services guidance that they put out this last summer. Some guidance that Health and Human Services put out to help retail pharmacies understand their obligations, and then also Health and Human Service guidance that they put out for patients about knowing their rights related to reproductive health care. So hopefully you'll find those helpful. Next, I think it's an interesting discussion to talk about HIPAA and reproductive protected health information, especially in light of these various laws where in some states they are going to be, they've criminalized, assisting with an abortion, having an abortion under certain circumstances. Of course, HIPAA generally prohibits healthcare providers from disclosing protected health information pursuant to subpoenas and other government demands unless certain conditions are satisfied. So there's certainly some concern, though, that with some of these state laws that there will be subpoenas issued where you'll have to disclose protected health information that could be used to prosecute providers or patients relative to these new laws. Now, Health and Human Services this last year put out some guidance related to this issue. But the interesting thing is that they don't, while they give this guidance, and it's great guidance, they don't squarely address the fact that if you receive a court order or a warrant or a subpoena that's signed by a judge or magistrate or a grand jury subpoena, if you fail to comply, that can result in fines and penalties. And so providers have to, in those situations, comply with those subpoenas or face the penalties, and that can include jail time in some cases. And so you really need to understand the various methods by which this information can be requested and make sure that you're following HIPAA very carefully and only be supplying and providing that PHI when you're commanded to, but that is only in the cases of these court orders, warrants, subpoenas signed by a judge. That doesn't include subpoenas signed by an attorney, but subpoenas signed by a judge or magistrate or a grand jury subpoena. And if Ashley will move to the next slide, to that point, I do want to just mention that we've got some, there are some really good resources on Holland & Hart's healthcare blog in regard to responding to subpoenas and orders and disclosures to law enforcement that Kim Stinger has put together that really helps guide you through each of those scenarios to know what you should do in those scenarios. And again, I'm linking here to this resource for Idaho abortion law update because Kim's also, again, put together a very nice resource for you there. If Ashley will turn to the next one. Again, some other additional resources. I think most of you have perused and received a lot of our client alerts and perused our health law blog, but there are, again, a lot of resources. We've linked to those here on this last slide. Also, there are some really good abortion law trackers that lay people can access without paying a subscription. The New York Times has a tracker, and then you've got the Guttmacher Institute has a state policies on abortion. So they're tracking this as well. And those are resources that you can access on your own. But again, if you want more nuanced and need more nuanced help, I would encourage you to contact myself or Kim Stenger or anybody in our healthcare group, because we can easily access the very fine-tuned trackers that are available on Lexis, our subscription-based legal subscription service. With that, I'll have Ashley, I think that might be the end of our slides, but we really appreciate everybody's participation. We know that there are a lot of question marks that remain, and a lot of things that just have to weave their way through the legal process before we have good definitive answers. But certainly, as things evolve, we try and keep you updated by issuing client alerts and posting those to our Help Law blog, and we will do our best to keep our clients updated to the best that we can. We appreciate your participation. For any questions that may have been posted, we will look at those after the webinar and reach out to you with answers to those questions as we can provide. So thank you all for participating. Ashley, thank you so much for your work and for your participation. And we look forward to the next webinar.
Thank you, Christy, and thanks everyone.